The most dangerous document in Florida business isn't a bad contract, it's a free one. Because a bad contract gets negotiated. A free template gets trusted. Every month, thousands of people follow a new LLC on sunbiz.org. They pay the fee, they get the certificate, but here's what the state never tells them. Florida does not issue an operating agreement. It doesn't require one. It doesn't even ask you if you have one. So most new business owners think, I'm official, I'm protected, I'm done. Then they Google free Florida operating agreement template, download it, the first PDF they find, sign it, and file it in a drawer. I call that document the lawsuit magnet because it doesn't protect you from litigation, it actually attracts it. Every blank, every missing clause, every vague sentence pulls a future dispute one step closer to a courthouse. Now, in the next few minutes, I'm going to show you exactly how these templates fail in Florida courtrooms, why a 50-50 partnership with a free template is a company with an expiration date, and the 5 clauses your agreement must have to keep a judge from reaching into your personal bank account. But first, you need to understand the trap Florida sets for you on day one. All right, let's dive into this one. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. And I want to be straight with you about something most videos get wrong. People think the danger of a free template is that it's low quality. That's not the danger. The danger is that in Florida, if your operating agreement doesn't address an issue, in Chapter 605, the Florida Revived LLC Act fills in the blank for you with the default rules you never agreed to. I call this the running on default settings. The state legislator wrote a one-size-fits-all rulebook for every LLC that doesn't write its own. A free template doesn't replace those defaults. It just papers over them because generic templates are written for no state in particular, and they skip exactly the issues where Florida's defaults will hurt you the most. Now you might be thinking, okay, has this actually destroyed companies? Well, let me show you the 2 places where it happens over and over again. And the second one is the reason I made this video. Scenario 1, 2 friends, 50-50, free template that says members shall manage the company jointly and nothing else. For 3 years, everything's great. Then they disagree on one big decision: hiring, a new location, selling the company. And here's what the template never told them. With no tie-breaking mechanism, neither one can outvote the other. The company can't act. Payroll decisions stall, and bank signatures freeze. And Florida law has a remedy for that situation: judicial dissolution. When an LLC's management is deadlocked and the deadlock is causing harm, a judge can order the company dissolved. Not fixed, not mediated, dissolved. The business you built gets liquidated because your free template has no answer for a tie vote. That's the 50-50 death spiral. Deadlock, paralysis, courthouse liquidation. And the worst part? Both partners lose. The only winners are the lawyers billing through the dissolution. But a deadlock isn't even the most common template failure. The most common one is what happens when a member wants out. Scenario 2. A member leaves, burnout, divorce, a better opportunity. It doesn't matter why. Most people assume if I leave, the company buys out my shares at a fair value. But under Florida's default rules, that's not what happens. A member who disassociates generally has no automatic right to be bought out. They typically keep only a bare economic interest, a right to distributions if and when the remaining members decide to make them. No vote, no management rights, no exit price. So the leaving member is trapped, holding a share they can't sell and can't control, and the remaining members are trapped with a ghost on the cap table. That's when people sue, not because anyone did anything wrong, but because the template was silent and Florida's defaults filled the silence. Real quick, if you're getting value out of this, hit subscribe. Every week, I break down the exact legal strategies Florida business owners only hear only after it's too late. And my goal is for you to hear them first. Because the next section isn't about losing your company, it's about losing your house. Now here are the 5 clauses that decide whether a judge can reach your personal assets. Now the entire reason you formed an LLC in the first place is a liability shield, the corporate veil. But the veil is not a certificate. It's a pattern of behavior, and your operating agreement is a blueprint for that pattern. Under Florida's leading veil-piercing standard, a court can hold you personally liable when the company is treated as a mere instrumentality of its owner and there's improper conduct, commingled funds, ignored formalities, an entity that exists only on paper. And when opposing counsel comes after your veil, the first document they subpoena is your operating agreement. If it's a generic template that you never followed, you've just handed them Exhibit A. So here are the 5 veil clauses, the 5 things a real Florida operating agreement must contain. The first one, a deadlock breaker, a buy-sell mechanism, a shotgun clause, a designated tiebreaker, anything that gives a tie vote an answer other than a judge. Number 2, exit and buyout terms, what triggers a buyout, how the shares get valued, and how it gets paid. This single clause prevents most member litigation that I see. Number 3, capital and separation rules. Defined contributions, a company bank account requirement, a flat prohibition on commingling. This is the clause that directly armors the veil. All right, number 4, management authority. Who can sign, who can borrow, who can bind the company in writing. Courts respect entities that respect their own structure. Number 5, transfer restrictions. Who can become a member, what happens on death or divorce, and a right of first refusal. Because without it, you can wake up in a business with your partner's ex-spouse. And believe me, I've seen it happen. Now you might be thinking, Santiago, lawyers always say don't use templates. You're a lawyer. Well, fair. So let me put it in business terms. A custom operating agreement cost you 4 figures just one time. The disputes I've described, deadlock dissolutions, exit fights, veil-piercing claims, run 6 figures routinely before anyone sees a courtroom. The free template isn't free at all. It's a deferred legal bill with interest. And by the time the lawsuit magnet pulls you into a courtroom, your options have already collapsed. You can't negotiate a buy-sell clause with a partner who's already suing you. So here's your move. If you have a Florida LLC running on a free template or on nothing at all, pull it out this week. Check it against the 5 veil clauses I just shared with you. If even one of them is missing, you're running on default settings, and the state's rulebook was not written to protect you. Sunbiz makes you official. Only your operating agreement makes you protected. Now, if you've learned something from this video, please like and subscribe. I post legal breakdowns like this every single week. I'm Santiago Cueto, your Florida business attorney. Watch this next video where I break down the critical protective business prenup clauses that a robust, customized operating agreement must include to avoid costly court battles.